Australia's Industrial Relations umpire, the Fair Work Commission, has recently held that the dismissal of an interior designer after sending a group email via LinkedIn advertising his part-time interior design business was not unjust or unreasonable. Well, here to tell us more about this and the wider implications for employers, our regular guest commentator Joydeep Kaur, Managing Principal of specialist workplace relations law firm People and Culture Strategies. Joydeep, great to see you. Now, this story is really interesting. Well, this finding too, I guess, as well. But firstly, just explain for us what this interior designer did and what he said in this email.
So this particular employee was working for an architectural firm in Canberra. It was the evidence in the case that he had been allowed from time to do certain small jobs on the side, outside of his working hours, so that part of it was acknowledged. But what he decided to do was to set up his own business, which was going to be in competition, although he said it wasn't going to strictly be in competition with his employer. Put out an email message on LinkedIn to his existing contacts, many of whom were clients of his employer, saying, hey guys, I'm setting up this new business. You get all the advantages of my big organisation expertise, but I'll be able to do the work for you cheaper. So how about you think about me for future work? The employer finds out about it, quite cleverly tries to work out whether or not he was actually doing that during work time, forms the view that he was, forms the view that that was a breach of his contract of employment, and makes a decision to terminate his employment.
And obviously the Fair Work Commission has upheld that the employer's stance.
They have, yeah. So what's interesting is that it's actually very unusual in unfair dismissal cases to find these kinds of matters agitated as claims for unfairness. I think a lot of people would say, well, I've been caught out, I might just let it go. But the other reason is that quite often these things play out in the Supreme Court more when an employer is pursuing the employee or former employee for loss of business or business opportunities as a result of their conduct. It's unusual to see it played out as an unfair dismissal case. Quite reassuring, I think, for employers that the Commission said no, he had a clear contract that required him to dedicate his duties and time to his employer's enterprise. Things start to get a little bit messy, and I think there is a takeaway for employers in this, that when you do allow employees to do certain things that could be seen to be competitive, even though you think you're clear as an employer that it should be outside of work and whatever else, it does introduce an element of confusion into the work relationship. I think employers should be very clear, and ideally they should be clear in the way they write their contracts as to exactly what an employee can and can't do. And the moment you start to muddy those waters in terms of saying, oh, it's okay if you do it, but it can't be on work time, you can't use work resources, but you can still effectively do the same thing. While it wasn't a fatal issue for the employer here, it's just a good lesson for employers in the future.
And in terms of other actions, I guess, that employers can take then, in regards to employees who they've found to have breached these non-competition obligations, is there anything else they can do other than, sack them?
Well, depending on what the consequences of the employee's conduct is. So if, for example, the evidence in this case, or the facts in this case, was that a lot of people did respond to that particular email message, a lot of the clients of the organisation did follow this particular person or took their work away from it, given that, strictly speaking, that would be considered a breach of the employee's fiduciary duties or duties of good faith to his employer, then the employer would have a right to pursue that employee, or ex-employee presumably by that stage, for what's called an account of profits. In other words, the profits that he derived from engaging in unlawful conduct, the unlawful conduct being a breach of his good faith obligations.
Well, it's really interesting. As always, thank you so much for this. Great to hear about that and some of the things that employers need to keep in mind. Thank you. Joydeep Kaur there from People and Culture Strategies.